Hello, and welcome along to How to Run a Grievance Process, a webinar that forms part of EW's How-To series. My name is Rachel Lamsley, and I'm a Senior Employment Law Advisor here at Ellis Whittam. Today we'll be discussing grievances and how they affect your business. In today's webinar, we'll take a look at spotting a grievance, the right to be accompanied, roles and responsibilities in the meeting, the investigating the grievance, findings, grievance appeals, and finally findings in relation to grievance appeals also. So let's get started then. Grievances are concerns or complaints that employees raise about their terms and conditions, other employees, or their employer more generally. Grievances come in all shapes and sizes and come in all forms, from a written letter or email, to be raised by telephone, verbally in person, or even by way of text message. So the key is to remember that we shouldn't ignore issues that are raised by staff, even if they come to us in a less than conventional format. The starting point is that all employers should have a procedure to deal with grievances and should try to follow it at all times. The basic principles of good practice in relation to handling grievance can be found in the ACAS Code of Practice. Failure to follow this code doesn't automatically give rise to a claim itself, but failure may lead to a tribunal upholding a complaint, for example, of unfair dismissal or discrimination. In such cases, there may also be an uplift of up to 25% in any compensation ultimately awarded to the employee by the tribunal, something we obviously want to avoid. Your grievance procedure should be set out in your employee handbook, and the ACAS code requires that the procedure be fair and transparent. You should ensure that all employees and managers know where to find the procedure and how to use it. Here at EW, we help you draft a grievance policy and procedure which is appropriate to your organisation. If an employee's grievance isn't dealt with properly and they walk out as a result, they may be able to have a claim for unfair dismissal, perhaps by way of constructive dismissal if they've got the requisite 2 years service. To successfully defend such claims, you'll need to show that you carried out a fair and reasonable process to deal with the grievance, taking into account all the circumstances of the case. So, both employees and employers should aim to settle grievances, if at all possible, informally. If not, the employee may raise the issue formally. Where the employee formally raises concerns, problems or complaints, then we should take a structured approach that's laid down in your grievance procedure. Once we've established that a grievance has been raised, we should invite the employee into a grievance meeting in order to discuss the concerns with the employee. The letter should identify who will deal with the grievance. This should be a manager who isn't involved. We should give the employee at least 48 hours notice, or longer if your policy states this. We should also give the employee the right to be accompanied, and finally enclose a copy of your policy with the letter so that everybody knows what process we're following. So let's take a look at the right to be accompanied in a little bit more detail. Employees have the right to be accompanied at grievance hearings and appeals that are concerned with a duty owed by the employer. In practice, it is safest always to offer the right to be accompanied. The person who accompanies the employee can either be a worker or a trade union official. An employee acting as a companion to another employee can take paid time off work to prepare for and attend a hearing. The companion or trade union rep should be allowed to put the employee's case forward, respond to any views expressed and confer with the employee, but they can't answer any questions put to the employee themselves. If an employee's chosen companion can't attend a grievance meeting at any time proposed by you, then the employee can ask for a postponement of up to 5 working days. Failing to give the right to be accompanied if this has been requested can result in a claim against the organisation, so we want to avoid getting it wrong. If you think you might deny a request for the right to be accompanied, then do take advice. So who's who in a grievance meeting then? Well, the chair is there to discuss the employee's concerns or problems or complaints, and where appropriate, to gather the information to be able to make a decision within the organisation's procedures as to whether to uphold the grievance or not. The employee is there to discuss their concerns or grievances, and give their view of events to enable the chair to make a decision. The representative or co-work can state the employee's case, ask questions, discuss things with the employees, but as I said earlier, they're not able to answer questions on behalf of the employee. Finally, I'd certainly suggest that you have a minute taker who takes notes, but is not somebody who forms part of the decision-making process. So what actually happens in the grievance meeting itself? Well, as the chair, I would confirm that the employee received the invite letter and use their grievance letter as an agenda for the meeting. I'd be sure to ask for clarification of further information to make sure that I establish the key points of the grievance. One of the key points that a chair needs to remember is to listen to the reasons why the employee is unhappy and ascertain from them the desired outcome. A word of warning, don't commit yourself to an outcome at the meeting. Simply thank the employee for attending and confirm that you'll be able to come back to them soon. So, the investigation itself then, we need to take into account a few things to make sure that we're going through a fair and thorough process. The chair or investigator should establish the facts as soon as reasonably practicable and should ensure that not only they but also witnesses are maintaining confidentiality. The investigator should remain impartial and objective, consider what your policies say, such as bullying and harassment, as well as your own grievance policy, and lastly, don't make assumptions. It's a surefire way to end up with an appeal. As part of the investigation, we might need to gather witness evidence. My key top tip in respect of this is to make sure that you're fully prepared in respect of the witness evidence. Consider who you need to speak to. Did the employee identify any witnesses, or did anybody else for that matter? Will you have a meeting with them or simply ask for a signed witness statement? Think about what you're actually trying to ascertain. Have a consideration towards the allegations that have been made. Also consider if the evidence is credible. Do you need to corroborate the information received? And if you are going to have a meeting with witnesses, prepare your questions ahead of time. It might not just be witness evidence that you need to gather. There could be a whole host of different types of evidence that you need to consider. So, things like documents, emails, letters, CCTV footage, and even phone records. Once you've collated all of the evidence, you might consider popping this into an investigation report. In this report, you should be objective, refer to evidence, and summarize the findings when you're thinking about deciding on your outcome. You're likely to need to have a further meeting with the employee to discuss your investigation prior to confirming the outcome to them. This allows you to review the evidence, obtain further information and evidence if the employee puts this forward, and it gives the employee the chance to comment on your possible findings. Once you've made a decision about your outcome, you're going to need to put this in a letter setting out the decision. Your decision should take into account the employee's evidence, any witness evidence or documentary evidence, your own policies and procedures, what the employee's desired outcome was, and I would be certain to be taking advice in respect of your outcome to make sure that it's fair and reasonable. An employee whose grievance has not been upheld must be given the opportunity to appeal, and a more senior person who's not been involved with the case should hear this appeal. What I would suggest you do is make sure that you give an appeal to the employee, setting out perhaps 5 to 10 working days from the outcome for them to put this appeal in. Any failure to give them this right can lead to an uplift in compensation. In terms of the employee's role from an appeal perspective, the employee should set out the grounds of appeal in writing without unreasonable delay, and it should be communicated to them that there's no further right of appeal unless your own policy allows it. Make sure that you invite the employee in for an appeal meeting, giving them the right to be accompanied. At that meeting, again, confirm that the employees received the invite letter and use the appeal letters as an agenda for the meeting so you don't miss anything out. Clarify anything you're unsure of, asking for further information, and establish the key points of their appeal. As with the grievance meeting, the chair should listen to the reasons why they're unhappy with the original outcome. establishing what their desired outcome is, and again, don't commit yourself to an outcome in the meeting. Thank them for attending and give yourself an opportunity to consider the appeal in detail. The appeal hearing should consider all the grounds the employee has raised as to why they don't agree with the original decision. The appeal officer needs to be satisfied that the original grievance finding was correct and reasonable in all of the circumstances. The appeal decision should be confirmed to the employee in writing as soon as possible. That outcome letter should set out the grounds of appeal, set out the findings for each of the grounds of appeal, and finally confirm if the grievance is upheld or not. That brings us to the end of today's webinar. To check out the rest of our how-to series, get in touch at inquiries@elliswhittam.com.